Can we do one more topic?
Yeah, ma'am, sure.
So otherwise, what happens is, we know the regular court process, right? Party would go to the court, case would go on for years, and after that matter would be decided by the court, right? Court would hear both the sides, evidences would be taken, witnesses would come. After that, court would decide the matter. So that is the usual process. But apart from that usual process where there is like a bit of delay, for many days case would go on, we have some alternate ways of resolving dispute also. Okay, so in functions of law, we have studied that law helps to resolve dispute between parties. If there is a dispute, law would help you to solve that. Now, in solving that dispute, we can go to the regular courts, or we have an alternate way as well. So this is nothing but alternate way of solving a dispute, and one of the examples is arbitration. So
can you give me some?
Sorry?
Can you give some other example, please?
Arbitration? For which one you want another example?
Like for this?
Arbitration.
Yes.
Arbitration. Yeah, I'm giving. We are into this topic, right? So I'm good. See, we have already studied in functions of law that disputes are bound to arise because we have so many people living in one society. We have differences in our interests, opinions, etc. So disputes are definitely unavoidable because we have different needs, wants, values, views, etc. Law provides a formal means for resolving disputes, that is the court system. If there is any kind of dispute, maybe violation of a contract, breach of a contract, we would go to court. If there is any question relating to validity of marriage, we would go to the court. If parties want to get divorced, they would go to the court. Regarding child custody, regarding adoption, regarding every single thing, they would go to the court in order to solve the dispute between them. But apart from going to the court, which is like the traditional way of solving a dispute, we have some alternate ways also, because there are lot many cases increasing. Courts are overburdened, cases go on for years and years. That is why there are some alternate ways, some different ways other than going to the court. There are some different ways of resolving dispute that has developed, and arbitration is one such example. What is arbitration? Arbitration is the process of solving an argument between people by helping them to agree to an acceptable solution. As in, it's not like court would decide that, okay, you were right, you were wrong, so you paid this much of compensation, you would suffer. Not like that. But what would happen is, there would be one arbitrator who will bring both the parties together. You will say that, okay, what are the differences? Are there anything where you can sacrifice? Are there anything where you can sacrifice, right? Both the parties would try to compromise, right? The party would say that, okay, fine, these things I can compromise. This one would say, okay, these things I can compromise. So together, right, they would try to figure out a solution, and that's how they would resolve the dispute. So it is solving an argument between people by helping them to agree to an acceptable solution. What is it that you can agree? What is it that this person can agree? Then both of you would enter into an arbitration agreement. Okay, so arbitration is nothing but a part of alternative dispute resolution, or ADR mechanism, that benefits parties who want to avoid the normal lengthy recourse to the local courts in settlement of dispute, because cases go on for 5, 6, 10, 15 years. So they need to go to the court for every hearing. They need to pay fees to the advocates, right? A lot of processes being involved. So rather than wasting your time, energy, and money, you have some alternate ways of resolving dispute. It is a legal technique for the resolution of dispute outside the courts, wherein parties to a dispute refer it to one or more persons, namely arbitrators. So there would be arbitrators who will help the parties in solving the dispute. The Indian law with respect to arbitration is largely based on English common law, and we have a legislation also named as Arbitration and Conciliation Act 1996. But then what are the advantages of arbitration? I'll give you first an example of what an arbitration is so that you understand. Okay.
Okay.
Take for example, there is a contract between two companies. Okay, there is a contract between two companies. Now, based on the contract, company A promised to supply maybe, right? A company is there. A company promised to supply goods at ₹5 to B every single month. Okay, every single month for 24 months. Okay, and this A company was able to get those goods for maybe ₹3. So they said that, okay, fine, we would be supplying it to you for ₹5. And this would happen for 24 months, same price we would charge. And this was the contract. But now, because of COVID, in transportation and everything, they need to do a lot of, maybe like sanitizing the things, so many procedures, SOPs and everything. So what happened is cost has increased. Now A is getting it for ₹6. Okay, that same goods, now A needs to buy it for ₹6. So when he would be giving it to B, he cannot give it for ₹5, right? Because it's practically not possible. He would be in loss while supplying that. Right, so A is giving it for it is having for ₹6. So he said that I cannot give it to you. I would charge at least ₹7 or ₹8. ₹7 or ₹8 I would charge, otherwise I cannot give you. Now in this case, what B can do is B can go to the regular courts, right? And he can file a case for breach of contractual terms, that A made a promise that for 24 months he would not increase the price. For ₹5 only he would be selling it, but now he is not following the terms. He is charging ₹7 or ₹8. When he goes to the court, what would happen is this case may go on for 3 years, 5 years, or even 10 years, right? It would involve a lot of time until and unless court has given a decision. What about this supply? B would not supply, A would not supply, right? B would anyways be suffering. B would be waiting for it because he thought that for 24 months it would be supplied. So if the case only goes on for beyond 24 months, after that court gives an order after 10 years, that might become meaningless. Plus, while filing this case and everything, B will have to hire a lawyer, go to the court for hearing. It would be unnecessarily waste of time for him because he is doing some business, right? Both of them are two companies. They don't want to waste their time in those things. So what they can do is, B would also understand, right? That, okay, fine, this person only is not able to get it in ₹5. How would he give me? Right? So maybe this person was charging, he was saying that, okay, ₹9 I would give. Because I'm getting it for ₹6, I would supply in ₹9. So in that case, rather than going to the court, waiting for years, both A and B can go to an arbitrator. Their arbitrator would ask them that, okay, what is the problem? And then they would explain this is the situation. So arbitrator would help them to come to a settlement. To A, arbitrator may say that, okay, fine, you are getting it for ₹6 now, fine. Why don't you give it for ₹7? Or why don't you give it for 8 rupees? Because you already entered into the contract, right? So 1 rupee you take profit and give it for 7 rupees. To B also, arbitrator may say that what is the problem? You are getting it for 5 rupees. You can pay 7 rupees, only 2 rupees extra, right? So both the parties may agree also. Okay, fine. 7 rupees I can pay or 7 rupees I can supply. This is nothing but both of them have sacrificed on their claims, right? They have tried to come to a settlement, come to a compromise. Like both of them would try to figure out a solution so that it happens very quickly. And based on whatever were the agreements between them, an award would be passed. Like it would be written, both the parties would put their signature and it will be binding on them just like a contract. So here what is happening is time is also saved, money is also saved, plus they are able to settle the dispute, right? They would be able to get the supply thing done rather than waiting for 10 years. Right? So this is how an arbitration works, that rather than going to the court, you have alternate ways of resolving dispute. And arbitration is some example of that. Is it clear?
Yes, ma'am.
Clear, right?
Yes, ma'am.
Now we would see what are the advantages of arbitration. Minimization or minimalization of court intervention. For every single thing, you may not need to go to the regular courts, right? We are trying to reduce intervention from the part of court. Reduction in cost of dispute redressal and resolution. You don't need to hire a lawyer. You don't need to go on for, like years and years and everything. This is nothing but reduction in cost and dispute resolution. Expeditious and timely disposal. On time, you were able to solve the dispute, right? You were able to come to a settlement. Enforcement of awards through neutrality of arbitrator. Whoever is the arbitrator, he would not be biased. He would be a neutral person who would not think about A's benefit or B's benefit, but he would be someone not related to the matter as such, right? So he will help the parties that, okay, you also sacrifice something, you also sacrifice something, and just settle the matter, right? So he would be a neutral person who will simply help them to come to a conclusion. Reduces burden of regular courts. Already these courts are overburdened, so you are again not filing a case and burdening them, but rather you are trying to solve the dispute by way of alternate ways of resolving dispute, right? So that's how they are having multiple advantages. And most of the times you would see companies and all, right, they would prefer arbitration if there is any kind of breach or conflict arising in relation to a contract, because there are multiple contracts that they enter into, right? They cannot have like thousands and thousands of cases pending for years and years. So they would try to settle the matter like this. Okay. Is it clear?
Yes, ma'am.
All right, fine. Okay, fine. So fine, and we'll end this class here. Okay, we will continue with the remaining topics in the next class.